So good afternoon, everyone, and good morning to some of the folks joining from the West Coast. Welcome to our webinar about the pros and cons of mandatory vaccinations in the workplace, hosted by Venable's Labor and Employment Lawyers. My name's Nick Reiter. I'm the co-chair of Venable's National Labor and Employment Group, and I'm joined today by my two friends and colleagues, Jen Przinsky and Janice Gregerson. As you might suspect, it's been a busy time for our employment lawyers. And if you think you have a lot of questions about the do's and don'ts of COVID-19 vaccination policies, rest assured that you're not alone. And frankly, all of our clients, all employers of every size and in every industry, they've been grappling with this issue. And while it's a bit of a new issue for a lot of employers and some of their counsel, I should point out that one of our presenters today, Janice Gregerson, she's been dealing with vaccination issues really ever since the start of her legal career. You see, Janice is also a member of our independent schools legal team, which represents several hundred independent schools across the country. And schools, unlike some other employers, they've been dealing with vaccination issues for their students and staff long before COVID-19 ever came around. So we're especially thankful to have Janice join us today so she can bring some of that prior experience to our program. Now, we're going to try to cover some of the more relevant vaccination topics today. We're going to talk about whether it's okay to require COVID-19 vaccinations for all of your employees. We're going to talk about what a mandatory vaccination policy should look like. But we're also going to talk about what employers can and should do if they don't want to go that far, if they don't want to go so far as to require that all of their employees get the COVID-19 vaccine. And we're going to walk through some real life examples involving situations when some of your clients might require that your employees who are coming onto the client worksite, when they have to be vaccinated. And finally, we're going to offer some advice about what to do when an employee refuses to come back to work and insists on working remotely, even after all employees are being called back to the regular worksite. Now, it would, of course, be really difficult, if not impossible, to cover all topics related to vaccines in just the hour that we have together. But there is a chat function for you to submit questions that you might have. And we're going to try to answer some of those questions towards the end of the program if we have some time. But for anybody who submits a question and their question isn't answered during our limited time today, we're going to grab those questions, synthesize any overlapping questions. And when we send you all the recording of today's program in a few days, we'll include those questions in our answers so that everybody can see our responses. I will point out just a little bit of a housekeeping matter. There is going to be CLE offered for attorneys who are in attendance. And Jennifer, about halfway through the program, will announce the code that you need to remember and write down to obtain CLE credit. So the first slide that we have here raises the fundamental question: may an employer require that its employees get the COVID-19 vaccine? And the EEOC, Equal Employment Opportunity Commission, has said, the short answer to that question is yes, but there are two very important exceptions. The first exception is a disability, a medical condition usually, that prevents the employee from being able to safely receive the vaccine. For example, if the employee is severely allergic to an ingredient called polysorbate, which is a main ingredient in one of the vaccines that's available right now, that might be a situation where the employee is excused from compliance with a mandatory vaccine policy, and there might need to be an accommodation of that employee's medical condition. The second exception, according to the EEOC, is a sincerely held religious belief or practice. So for example, if the tenets of an employee's religion prohibits vaccination. Now note though, on this slide, we've emphasized the word sincerely. And I'll use an example to show you what I mean by that. Every once in a while, employment lawyers like us, we get a call from a client, and the client says, we have this employee, Steve. We have to send Steve to this far remote place in the world as part of his job for a moment, for a project. Traveling to that part of the world requires a vaccine. And Steve just said that he just started practicing and subscribing to the Tao of Steve. And Steve has said that the Tao of Steve says that vaccines are a no-no for Steve and anybody else who follows the Tao of Steve. And you might be laughing and it might be an extreme example, but these are the things that come across our desk sometimes that our clients deal with sometimes. And I offer this example to show that the EEOC has said an employer does not need to just automatically accept an employee's claim that he or she has a religious belief that prohibits vaccination. An employer is allowed to ask questions to evaluate the sincerity of that religious belief or practice. Very similar in the medical condition or disability context. When an employee requests a medical leave, the employer is allowed to ask for a doctor's note, or even in some cases to ask the employee to obtain a second medical opinion to evaluate the legitimacy of the medical need. Now, if an employee has a disability or a sincerely held religious belief or practice that prevents the employee from getting vaccinated, then the employer has an obligation to try to accommodate that employee so long as the accommodation doesn't pose an undue hardship. And common accommodations would include maybe allowing that employee to work remotely for a period of time, maybe providing the employee a different office space that permits more social distancing, or in some cases, it could be a temporary leave of absence. There are other options too. Janice is going to talk in more detail just in a moment about some accommodation issues, so I won't go further there. You see here, though, in the middle of this first slide, there's a bullet point about asking for proof of vaccination, and that's allowed. You're allowed to ask for an employee's vaccine card. You don't have to go by the honor system. That's not required. And as Jen's going to discuss a little bit later, relying on the honor system can present some issues sometimes. There's pros and cons there. Keep in mind, though, that if you are going to inquire, if your organization is going to ask its employees about vaccination status, that inquiry should be pretty limited. And I'll use another example to illustrate this point. So if your organization is merely asking its employees, yes or no, are you vaccinated? Well, that type of inquiry is probably not going to cross the line into a disability-related inquiry. Even if the employee says, no, I'm not vaccinated, if the inquiry ends there, then you're not really eliciting medical information or disability-related information, and that's generally a good thing. But if you're going to ask for more information, namely, if your organization is going to ask employees, well, why are you not vaccinated? Well, you can begin to see how that may require the disclosure of some medical information or disability-related information. And one situation that's been cropping up for a couple of our clients, as we're coming back to work in the office, or if we're just on these group Zoom calls still, we've had a couple of situations where a manager has asked everybody in a meeting or on a Zoom call, hey, raise your hand if you're vaccinated or not. And then for the one or two people, or more who might not raise their hand, the manager might ask them in front of everybody else, well, why aren't you vaccinated? Well, that's, from an employment law, from an HR standpoint, that's not a great situation. That's a situation where a manager is asking employees potentially to volunteer medical information or disability-related information in front of their colleagues. You would never, for example, tell a manager that it's okay to ask an employee in front of a group of colleagues, hey, are you pregnant? You wouldn't do that. And it's an analogous situation. If your organization is going to make a further inquiry about why an employee may not be vaccinated, that could be okay so long as it's related to a job necessity, but it should be done in a confidential setting. And the information should be kept confidential and really just shared on a need-to-know basis only. And finally, for this slide, I want to offer a comment about emergency use authorization status of the COVID-19 vaccines. There's been some confusion about what that emergency use authorization status might mean. We've been getting some calls from clients that say, hey, my employees are saying, I don't have to get the vaccine, even if there is a mandatory vaccination policy because of the emergency use authorization status. And this really highlights the difference between the Food and Drug Administration and the EEOC, the two different domains that those agencies occupy. You see, the FDA, yes, it said that this is just an emergency use authorization status for the time being. A lot of the vaccine makers have an application to lift the emergency use authorization status that's pending. But the EEOC has just issued guidance recently that said Well, that status doesn't affect a private employer's ability to require vaccinations as a condition of employment. So what does this mean? It looks like there's a conflict there. Well, it means that public sector employees, federal government agencies, they're probably not going to require the vaccine for employees while it's still an emergency use authorization status. But private sector employees, they're free to do what they want in terms of a mandatory vaccination policy right now. And just 4 days ago, last Friday, you see the case site at the bottom of the slide here, a federal judge in Texas dismissed a lawsuit filed by about 117 plaintiffs, employees who worked at a hospital. They were challenging the hospital employer's mandatory vaccination policy. And the court said that as at-will employees, the plaintiffs, the employees, they don't have a right to stay employed if they refuse to comply with their employer's mandatory vaccination policy. So that's just a little bit of the lay of the land for whether an employee may require employees to get vaccinated. Now I'm going to hand it off to Janice to discuss what a mandatory vaccination policy should look like.
Great, thanks, Nick. We'll walk through how to craft the mandatory vaccination policy, what are the components that we want to see in there, as well as how to actually implement it. I'm seeing a lot of questions in the chat, the Q&A about the interactive process and the dialogue for accommodating religion and disability. But up at the front, right, we have to have a policy in place so that employees understand what's expected of them. I always think it's helpful to explain the purpose of the policy right at the outset. It's an additional health and safety measure. And I think the key word in that phrase is additional safety and health and safety measure. Depending on your industry that you work in, you're likely not going to be abandoning some of the other health and safety measures that you've put in place or protocols that have been in place. I think, particularly speaking to the educational industry and the schools on this call, you're going to have a lot of unvaccinated students still in your population, and you do have to remember your duty and obligation to keep them safe and healthy while they're on campus. You'll want to identify which employees are required to comply with this policy if in fact you're going to have a policy that separates out employees by their category or classification. So, perhaps you're going to require the more public-facing employees that interact with members of the public that are coming through or things of that nature to require, but maybe not employees who can socially distance in office spaces or things of that nature. We'll talk a little bit more on implementing the policy, how we should think about that and the considerations that should come into play. You'll want to have a date certain by which employees have to be fully vaccinated, meaning 14 days have elapsed since either their second dose of the Moderna or Pfizer vaccines or their single dose of the Johnson & Johnson vaccines. I recommend fully spelling that out in there, that specify a date certain when they have to be fully vaccinated. Of course, to Nick's point earlier, and which Jen will talk about a little bit later as well, we want to get documentation from employees that they actually did receive the vaccine. There's pros and cons to the honor system. That documentation should be limited, should be a copy of the vaccination card only, right? The government's made it really easy for us. We have these nice little vaccination cards that just say what dose, what batch it came from, and the date that you got the vaccine. It's really important to not abandon the other practices that we normally have in place about obtaining medical information from employees. So make sure that you maintain that proof of vaccination in a separate confidential file, not in the personnel file. That's going to be considered medical information about the employee that we should keep in a separate file. And let employees know that in your policy as well, so that they understand that we're not just gathering their medical information and just placing it about willy-nilly. Make sure that employees understand that accommodations may be made due to a sincerely held religious belief or due to a disability. This is going to work cohesively and consistently with what is likely already an accommodations policy that you have in place elsewhere in your employee handbook or wherever your employee-facing policies live. I recommend hardwiring the discussion of accommodations directly into this policy instead of cross-referencing back. Let's make it easy for people so that everything's in one place and they can understand what the expectations are for them. Again, I would identify a point of contact who's going to be responsible for receiving accommodation requests. Ideally, you want to make this someone who is in your HR office, who is familiar with handling and processing accommodation requests. Let's not make employees go to their individual managers or supervisors to request an accommodation. We want to try to keep those two lines of communication separate if we can. And then the other piece or component is paid time off. Depending on the category of employee and where you are, you may or may not be required to provide paid time off. So if we are mandating that employees receive the vaccine for a non-exempt employee, remember that's an employee that's eligible for overtime, we are going to be required to provide them with paid time off to receive the vaccine. Exempt employees, you're not required to provide them with paid time off to receive the vaccine, but it's a good idea to consider saying to them in that policy, we're not going to charge against your otherwise available PTO if you need to go when you go and get the vaccination. It's just another way that we can make this easy on employees. Make sure that you also take a look at your state law and see whether or not your state has affirmatively required you to provide paid time off for employees to receive the vaccine. States like New York, Illinois, and California have affirmatively created mandates of that nature. New York, for example, requires 4 hours of paid time off per dose. Illinois and California have embedded it in their otherwise existing COVID-19 leave. So make sure that you double check that and understand whether or not you're required to provide paid time off. Another good thing to consider is providing PTO for an employee to recuperate from any after effects of vaccination. We do know it's quite common, maybe a day or so after, to feel a little achy, a little sore. We don't want to penalize employees for getting the vaccine. We don't want them to make them feel like they have to use their vacation days because they got the vaccine because we required it. So consider doing that. It's a little thing that can go quite a long way in making sure that your employees are getting the vaccine. Think also too, if you voluntarily extended your FFCRA leave. Remember, FFCRA is can be voluntarily extended through September 30th, 2021, and you can claim the tax credit. An additional reason for leave under the FFCRA now is also vaccination. So you just want to be aware of that paid leave and how it interacts with your existing policies. Nick, can we go to the next slide? Okay, so now the meat and potatoes of it, right? Implementing the policy. So we have the policy in place. Now, how do we actually implement it? Let's not forget our general policies and practices on accommodations. I think this is something that's been a little bit challenging for employers over the course of the past year. Normally we'd get maybe 1, 2, 3 accommodation requests over a year. And now we're getting them more regularly, and particularly with returning to work and vaccination mandates, but you would expect that you might get a couple more accommodation requests than you normally do. Remember basic ground rules for an accommodation. They should all be assessed on an individualized basis. That means that you consider the information that the employee has put forward, and you make a determination of whether or not and which accommodation you can provide. Remember, you don't have to provide the accommodation that the employee requests, just a reasonable one. Remember too, there's no requirement to accommodate a personal objection. So, and going back to the schools, we're familiar with this concept of mandatory vaccines to go to school, to be on campus at school. Depending on the state, we have a medical exemption, a religious exemption, and a personal objection. Here, with an employee mandate vaccination policy, there is no personal objection under the law. So there's no requirement to accommodate an employee who just otherwise feels uncomfortable about receiving the vaccine. When we're getting ready to roll a vaccination policy out, it's a good idea to dust off your existing accommodation policy and train your managers. Your managers should be aware, even if they are not the ones that are going to be receiving the actual request for accommodation, they should understand that there are no magic words to trigger the accommodation process. So if they have an employee that comes to them and says, hey, I'm really concerned about this vaccine policy, my faith doesn't allow me to use medicine, that should send off a light bulb for that manager to go ahead and contact someone in HR, whoever the contact is, to make sure that we follow the process. So for the disability accommodation, we don't just take people at their word. We want to request medical documentation. The medical documentation that you're going to want to see for an employee who's saying that they cannot receive the vaccine is that they have a condition where they would be harmed, a medical contraindication to receiving the COVID-19 vaccine, not just any vaccine, the COVID-19 vaccine. You're going to ask yourself, does the presence of an unvaccinated employee in the workplace pose a direct threat? Depending on the nature of your industry, arguably yes, particularly if you have a large unvaccinated population like schools or a public-facing organization. Under the law, you have to provide a reasonable accommodation that would not pose an undue hardship for disability purposes, for ADA purposes. That means a significant, the undue hardship is a significant difficulty or expense. That's the phrase that you want to have in your mind. For religion, the duty to accommodate is coming under Title VII, the General Anti-Discrimination Law. The definition is broad, but like Nick alluded to earlier, the belief has to be sincerely held. You are allowed to ask and question whether there's an objective basis for questioning the sincerely held nature of the belief. A common one that I hear and that I have actually been dealing with over the course of the past few weeks is a religious belief that God created the perfect immune system. And so because God created my perfect immune system, it would be an offense to God if I take the COVID-19 vaccine. Well, but we also know that that employee took antibiotics when they needed them later, that that employee also has an EpiPen, that they use medical intervention. So those are the kind of things that you can look to test whether there's an objective basis for questioning the sincerity of that religious belief, whether that employee actually lives by that day to day, or whether they're just doing it to try to get out of your vaccine mandate. For purposes of the religious accommodation, providing the reasonable accommodation, that word undue hardship again, means having more than a minimal cost or burden on the employer. Nick, if we can flip to the next slide. Okay. Oh, thank you. You're going to want to assess any potential for disparate treatment or disparate impact, particularly if you're implementing a mandatory vaccination policy that differs on the basis of employee classification. You want to make sure you make that assessment and look to the federal protected categories, as well as any categories or classifications protected by state law, and see whether you are having an impact on one classification more so than another. That doesn't mean you can't necessarily do it. If you have a legitimate non-discriminatory reason for doing so, just know that, go into that eyes wide open. You'll also want to consider whether there are employees who might have greater difficulty receiving the vaccine and would be more negatively impacted by this policy. Again, given the availability of the vaccine in the United States, that concern may go away, particularly as we continue to go through the summer and we see these lovely lottery entries for getting vaccine. But just consider that as well. Just make sure that you go in eyes wide open with this policy. Okay, so here's the million-dollar question. An employee that refuses to comply. Absent an accommodation that has been granted, an employee should be expected to fully comply with this policy. And remember, you know, the world of accommodation can be pretty broad. Maybe it can be additional PPE. Maybe that employee undergoes additional testing. Maybe that employee is permitted to work remotely if your industry or your work site allows you to continue remote work. Depending on your operations, that may or may not be feasible for you. Remember, unpaid leave of absence is always an accommodation. Again, it's not the accommodation that the employee wants, it's the accommodation that's going to be effective. And if the accommodation that's going to be effective is giving someone an unpaid leave of absence for a set period of time so that you can protect the health and safety of your community, of your workforce, then that's going to be the accommodation you're going to want to put in place. But an employee that doesn't have an accommodation, that doesn't have that unpaid leave of absence, for example, well, you may be left with no other option but to part ways with that employee because they're refusing to comply with the policy. Referring back to the Houston Methodist decision that came out late last week, it's a great line in the very last line of the decision. If a worker refuses an assignment, changed office, earlier start time, or other directive, he may be properly fired. Every employment includes limits on the worker's behavior in exchange for his remuneration. That is all part of the bargain. So that's kind of the outline of implementing a mandatory vaccination policy. Jen, I'll toss it over to you to discuss some alternatives to a mandatory vaccination policy.
Great, thanks so much, Janice, I appreciate it. For those of you who are taking this for CLE credit, the CLE code is vaccine. Again, the CLE code is vaccine. So some of you may be thinking to yourselves, you know, a mandatory vaccination policy may not be the right choice for our workforce. But if that's not the right choice, then what should our COVID-19 policies look like? Now, Janice has done a really fantastic job of laying out what the elements of a policy should look like, and you should adhere to that format. But when you're trying to look for the specifics of what your policy should look like, if you're not going to implement a mandatory vaccination policy, then you'll want to look to the applicable guidance. So depending on where your offices are located, there may be a significant amount of guidance that's applicable to your workplace, and you'll need to make sure you're taking a look at that. So in addition to the federal CDC guidance, each state has its own guidance, as well as some cities and counties have their own guidance as well. Most of you have heard recently that there are federal OSHA standards that came out that are applicable to the healthcare setting, and OSHA has even issued some guidance for those employers in the non-healthcare setting. So make sure you take a look at those as well. But for purposes of today's discussion, I want to focus on the most recent CDC guidance related to vaccinated individuals, because these are the questions that we're really getting from our clients. And I think this is an area that's causing a bit of confusion. So I want to talk a little bit about it, and then talk about how the difference in treatment with regard to fully vaccinated individuals and non-fully vaccinated individuals may be incorporated into your workplace policies. So what does the CDC guidance actually say? So the guidance essentially relaxes requirements for vaccinated individuals while keeping all the other protocols in place. More specifically, fully vaccinated individuals are exempt from wearing masks and social distancing, except where it's required by federal, state, local laws, rules, or regulations. Fully vaccinated individuals who have been around someone who's had COVID-19 don't need to stay away from others. They don't need to get tested unless some COVID-19 symptoms appear. For those fully vaccinated individuals who engage in domestic travel, they don't have to get tested before or after the travel, and they don't have to self-quarantine after the travel's over. Now, there are still some requirements in place for fully vaccinated individuals who have engaged in international travel, but even those requirements are a little more relaxed under the new guidance. And as Janice had mentioned earlier, under the CDC guidance, fully vaccinated means 2 weeks have passed since the last dose in the vaccine series, and that's going to depend, of course, on the vaccine that the individual took. So those are fully vaccinated individuals, but those who are not fully vaccinated, under the CDC guidance, they still have to wear masks, still have to social distance, and still have to adhere to those more stringent quarantine and travel requirements that were in place prior to this new guidance. Nick, could I have the next slide, please? So with respect to state and local guidance, of course, it's going to vary from state to state, city to city, and county to county. But there's some things you should keep in mind when you're actually reviewing this guidance. And make sure you do look at the guidance, because here's why. Not all state and local guidance at this time actually mirrors the CDC guidance. So don't assume just because the federal CDC has come out with these relaxed requirements that the state and cities that are guidance that are applicable to your jurisdiction also mirror that guidance. Some states and localities have generally lifting the masking and social distancing requirements for individuals, but they still have in place kind of general guidelines for businesses to adhere to, which may include social distancing or masking. And they also may have some guidance and requirements with regard to specific industries. There's some state and localities that have generally lifted masking, but not social distancing. And then other guidance even goes as far as addressing protocols that are appropriate for environments where there's this mix of vaccinated and unvaccinated individuals. So you want to make sure you take all of that into account when you're trying to determine what your non-mandatory vaccination COVID-19 policies would look like. And here's the key. If after you're looking at all the guidance, if your state and local guidance is more stringent and more restrictive than the federal CDC guidance, you're going to want to follow that more stringent state and local guidance, right? Because that's what's going to be applicable to you. Could I have the next slide, please, Nick? So what should your policy look like if you're not going to have a mandatory vaccination policy? So if state and local guidance do not reflect the CDC guidance, and they haven't lifted masking and social distancing requirements for your business, the answer is easy. Your COVID policy should follow that state and local guidance and keep the more stringent protocols in place. But what if your state and local guidance mirrors the federal guidance and has lifted masking and social distancing for your business. What are your options for your COVID-19 policy? Well, you've got two options here. The first option is to go ahead and implement a policy that is more stringent than the federal, state, and local guidance. And you can go ahead and have masking and social distancing requirements for all employees, regardless if they've been fully vaccinated or not. And you may say to yourself, is that right? But the guidance says I should be treating them differently. But really, as the employer, you have the discretion to implement protocols that you deem are appropriate. So it's perfectly fine to apply the same masking and social distancing protocols to all employees. And in fact, the CDC guidance actually gives a nod to this concept. And so for fully vaccinated employees, it goes down the list. You don't have to wear the mask. You don't have to social distance, but it says, quote, you still need to follow the guidance at your workplace. So again, if it's best for your workforce, you can continue to have masking and social distancing requirements in place for all employees. However, what we're hearing a lot of questions about is what I'm going to talk about in option 2. So if it's permitted on your state and local guidance, option 2 for your COVID-19 policy would be to implement COVID-19 policies that treat vaccinated and unvaccinated individual employees differently. And to illustrate how this may work, I have a little hypothetical situation here. Next slide, please. So here's the hypothetical. State A is going to go ahead and exempt vaccinated individuals from mask wearing requirements, and there's no other restrictions. So the employer says, okay, I want to treat vaccinated employees and unvaccinated employees differently. Now, the first question is, should the employer have a policy that says, if you're unvaccinated, you have to wear a mask, and not document the vaccination status, but instead allow unvaccinated employees to use the honor system with regard to mask wearing? As a matter of best practice, the answer here is probably going to be no. And so you might be asking, and I've had this question from a lot of clients, is why is the honor system not sufficient for these purposes? Well, think about it. Employers have an obligation to take measures to protect the safety and health of all employees, including reducing the risk that employees are going to contract COVID. So in order to meet this obligation, employers should be taking affirmative steps to ensure that employees who say they're fully vaccinated actually are fully vaccinated, so to reduce that overall risk. And you also may be asking, well, why would an unvaccinated employee not adhere to the honor system? Everybody cares about one another, so they're going to adhere to the honor system. Well, think about it. Just play this out for a second. If the employer is allowing vaccinated employees not to wear a mask and requiring unvaccinated employees to wear a mask, it's going to be very easy to figure out who's been vaccinated, who's not been vaccinated. And for some individuals, as we all know, the vaccination issue is a very highly charged issue. And so this dynamic may result in unvaccinated employees feeling pressure, and they might not follow that honor system, and they might end up not wearing a mask, and thus they're increasing the risk that other folks in the workplace are going to be exposed to COVID. So let me give you a couple of alternatives to the honor system. One, you can ask the employees for proof of vaccination. So you say, fully vaccinated employees, if you don't want to wear a mask, submit proof of your vaccination, your vaccine card. Or maybe a more minimal approach, if you don't want to go through collecting that medical record, you can go ahead and have the employee sign an attestation stating that they're fully vaccinated. Simple as that. And I know some of you are thinking, but wait a second, an employee could falsify that attestation, and that's correct. But however, if you think about it, when somebody actually has to sign a piece of paper, particularly a piece of paper, or even electronically, that says everything is accurate that I'm signing here, right, and I'm agreeing to it, it really is going to decrease the chances that that employee is being dishonest in submitting that attestation. So now you've heard about mandatory and non-mandatory vaccination policies, and what's the right policy for your workforce? And I want to say there really isn't an easy answer here, because each comes with pros and cons, and quite frankly, no matter what policy you implement, you can't really please everybody. If you say all employees have to wear a mask, fully vaccinated employees who only have to wear a mask in the workplace may not be happy. If you don't have a mandatory vaccination policy, employees who who aren't vaccinated or don't want to be vaccinated may feel that you're forcing them into it. So again, it's very difficult. But regardless of how whatever policy that you choose to implement, you should just be making sure that you're taking steps to ensure the policy is actually enforced. So while it's great to have these written policies, and again, Janice did a fantastic job of spelling that all out, we do want to make sure we're taking steps to make sure those policies are enforced. And with that, I am going to turn it back over to Janice.
Okay. Thanks, Jen. So even if we're not mandating vaccines, even if we're choosing to go a voluntary permissive route, there are other ways that we can encourage employees to voluntarily receive the vaccine, including the PTO considerations that we discussed earlier with the mandated vaccine. We are all probably familiar with employee wellness programs. An employee wellness program is a way that we can encourage employees to be healthier. They can be goal-oriented. They can be achievement-oriented, losing a certain amount of weight. A vaccination program, a voluntary vaccination program is another way that we can incentivize employees to receive the vaccine, just like we do with smoking cessation classes or things of that nature. Just like before, if you have a voluntary vaccination incentive program, you can also collect documentation demonstrating that the employee actually received the vaccine, and I would encourage you to go ahead and collect that information. We want to make sure if we're rewarding employees for receiving the vaccine that they actually got it. Remember, we want to keep this information confidential, just like we did before. We don't keep it in a personnel file. We keep it in a separate confidential medical information file, so it's not just out there in the ether. The crucial question with a voluntary incentive program is the parameters of the specific incentive. The meaning of voluntary is a little bit in flux, as with most things. When we have a new administration come into the White House, we have some changes. Some guidance is pulled back, the pendulum shifts. And so too are we seeing that with voluntary and with voluntary wellness incentive programs here. The prior guidance, or which is actually the current guidance in place right now, is that for a program to be voluntary, the benefit, the reward, the award, however we want to phrase it, that the employee receives for participating in the program cannot exceed 30% of the contribution that they would make of self-only healthcare coverage. Meaning, if the employee's healthcare coverage, for example, self-only is $3,000. I'm making up round numbers because I sometimes find math very challenging. With that incentive could not exceed 30% of that cost of that $3,000. That's the current guidelines. In January 2021, we had some initial rules come out saying, well, that's a little bit too much. If you think about it, that's quite a bit of money. The January 2021, proposed rules said that a permissive incentive cannot be so substantial as to be considered coercive, which is the general understanding, but has to be more closer on the spectrum to de minimis. So something like a water bottle, t-shirt, gift card of a modest value. There is some expectation that we might see this finally align itself somewhere in between de minimis and this 30%, the cost of self-only healthcare coverage. To be on the safe side, I would encourage everyone to think, if we are going to implement a voluntary vaccine incentive program, to be a little bit more closer to that de minimis side. Water bottle, everybody loves a promotional t-shirt, $25 gift card to Starbucks, whatever it is. When the award or reward for getting the vaccine is more substantial, so $50 monthly penalty, that's going to be a pretty hard hit depending on the employee. Paying for a gym membership, that's going to be pretty expensive. Paying for airline tickets, if you get the vaccine, we'll fly you out to Hawaii so you can have a lovely vacation. Again, that's going to be considered too substantial, and it's going to be coercive and then not truly voluntary. So I would keep that in mind. We can keep an eye on whether and to what extent the January 2021 proposed rules actually end up going into effect. They've been withdrawn. There's a pause on them for now, but hopefully we'll see some movement on that later so you can have some more definitive guidance. Again, as with anything, there is an accommodation requirement So you do have to make an accommodation to allow an employee that's not otherwise able or eligible to participate in the program to also receive the incentive. So for example, instead of receiving the vaccine, they can go ahead and attend a health and safety training, and they can also get the promotional t-shirt, water bottle, whatever it is, as well. And I think we'll turn it back to Jen to discuss another hypothetical.
Great, thanks so much, Janice. So let's say you elect not to have a mandatory vaccination policy, but you have a customer that says it wants all of your employees who provide services to be vaccinated. What do you do? Well, for this question, as Janice said, I've got a hypothetical for you. So here's the hypothetical. Employer A provides on-site services to customers X, Y, and Z pursuant to certain contracts. Employer A does not have a mandatory vaccination policy, but customer X has informed employer A that all of employer A's employees who provide on-site services must be vaccinated. Customer Y has asked employer A how many of its employees who provide on-site services are vaccinated, and customer Z hasn't said anything to employer A at all. Okay, so we're going to talk about customer X and we're going to talk about customer Y. So the first question here is, can employer A require employees who service customer X to be vaccinated, but not require employees who service customers Y and Z to be vaccinated? Now, at the outset, I do want to mention if customer X is a federal agency, employer A should know that federal guidance provides that federal agencies should not require federal contractor employees to be vaccinated. However, federal contractors and other private employers certainly can decide independently to require their own employees to be vaccinated. So assuming that customer X is not a federal agency, it's fine for customer A to require its employees who service customer X to be vaccinated, but not require employees who service customers Y and Z to be vaccinated. But because employer A is going to be applying different policies to different groups of employees, employer A is going to want to consider the form of customer X's request. Now, if customer X has sent over an amendment to the contract and it requires employees to be vaccinated, that's an appropriate form for the request. However, if customer X mentions in passing to employer A, we'd really like for your employees to be vaccinated, it's really a good idea for customer A to say, you know what, customer X, can you just put that in writing and then we can go ahead and amend the contract accordingly, right? Just keeping things nice, neat, and documented, particularly when we're treating groups of employees differently. So let's say employer A signs an amendment to customer X's contract, agreeing that employees are going to be vaccinated. How should employer A communicate this to the relevant and affected employees? The inclination may be that customer A sends an email to all employees who work on customer X's contract and says, go get vaccinated. And because this is a contractual requirement that our customer tells us that we have to do, if you don't get vaccinated, you're going to be terminated. But let's think about this a little bit more. Employer A, not customer X, is the employer, right? And employer A is the one that has implemented the mandatory vaccination policy, even though it's just done so at the direction of customer X. So the mere fact that customer X asked employer A to make sure that only vaccinated employees work on their contract does not relieve employer A of its obligation to provide accommodations under the Americans with Disabilities Act and Title VII, right? So rather than sending that email that we talked about, employer A should implement a written mandatory vaccination policy for the employees who work on customer X's contract with clear steps on how to request accommodations for disabilities and sincerely held religious beliefs. And Janice talked about that earlier in the presentation, so you know what that should look like. So let's say though, after employer A implements that policy, employer A gets a request for a vaccine exemption based on a disability or religious belief. What should it do? Employer A should go and try to talk to customer X about this and try to accommodate the employee. That's the obligation here. Employer A should make sure that it keeps written documentation of its interactions with customer X. And the reason for that is that documentation is going to be able to, if necessary, be able to demonstrate that employer A really did engage in the interactive process and efforts to accommodate that individual. And depending on the service that employer A's employees provide to customer X, accommodations like telework or maybe more stringent protocols like additional PPE may not be available. Or maybe customer X is just really difficult and says, no vaccinated, no unvaccinated employees can work on my contract. They just can't work on it. So should employer A fire the employee at that time? The answer is no. One more step here. Although employer A has to remove the employee from the contract because it's contractually obligated to do so, it's tried to engage in the interactive process, but is being stonewalled by customer X. Employer A should look to see if there's an open available position for that employee on other contracts that don't require the employees to be vaccinated, right? Because we still have customer Y and customer Z's contracts. If there are no open positions, a layoff may be appropriate, but you should certainly employer A certainly should take those steps before separating the employee to try to minimize potential liability here. So let's turn to customer Y here. The question is, can employer A provide the number of employees vaccinated that have been vaccinated to customer Y? I mean, I think the first question here is, what does customer Y intend to do with the information? So if the president of customer Y asks the president of customer A, how many employees who work on the contract are vaccinated, they should say, what do you think, why do you need the information? If customer Y is just curious, employer A can say, we don't really give out that information unless it's in response to a formal request. If it's a more formal request and customer Y says, well, we really need this information to determine whether we're going to require employees to be vaccinated. Maybe your numbers are high enough that they're not going to require mandatory vaccination. And that's the data that they want to assess whether a mandatory vaccination policy is necessary. Employer A can go ahead and obtain the information and provide it to customer Y, but under really kind of certain conditions. So how should employer A go about obtaining this information from the employees about their vaccination status? As Nick said earlier, walking around asking employees, are you vaccinated? Are you vaccinated? It's not the best way to do it. And particularly here, probably the better way to obtain the information is to send out an anonymous survey and asking the employees whether they're vaccinated, or if they're not vaccinated, whether they intend to be vaccinated, and then share with them that this type of anonymized information may actually be shared with customers. And then employer A can go ahead and provide the information to customer Y, but really they should say, listen, this information should be treated as confidential. You can use it for this limited purpose, right, of assessing whether you think a mandatory vaccination policy is necessary. And if you're going to share it outside upper management within your organization, you're going to have to require permission for us. You have to ask us first. And those steps will help insulate keeping that information confidential and ensuring it's not widely disseminated. And with that, I'm going to kick it back to Nick.
Thanks, Jen. So thanks everyone for bearing with us so far. We're on our last slide before we're going to try to answer a few questions and get everybody out before the 3 o'clock hour here on the East Coast, at least. So the last slide here, it raises the question, and some of you have already asked this in the chat function about, Jen, if I could just have you go on mute, because I think I'm having some trouble getting picked up. It asks, well, let's say you have all your policies in place and you've got, you've decided mandatory vaccination or not mandatory vaccination, but we're going to encourage our employees, we're going to incentivize them to get vaccinated. We've got our rules in place for people who are sorry, I'm being prompted just to remind everybody that the CLE code is vaccine one more time. You've got your rules in place for people who are vaccinated. They're not going to wear their masks. People who are not vaccinated and the rules they're going to have to observe when they come into the workplace. And then you start to tell your employees, now that you got all your policies in order, you tell them, all right, it's time to come back to work. Different employers are going to do that at different times over the course of the calendar. But let's say you do that, and then employees say, well, I don't want to come back to work at the work site. I'm going to keep working remotely. What happens then? And it's questions like these where I like to remind employers, and sometimes where I have to remind a plaintiff, say at a deposition, about the meaning of at-will employment. And we don't mean to be harsh or unfair about it, but at-will employment is where a lot of employment law analysis begins. And it means, as a lot of you know, that either party to the employment relationship, the employer or the employee, they can terminate the employment relationship at any time when they want to, for any reason that's not illegal under law, and with or without notice. And what that means in this situation, when you have an at-will employee who refuses to come back to the work site, is that the employer can insist that the employee returns to the work site or loses their job. And here's the important part: so long as the employee does not have a legally protected right to work remotely. And this last slide includes some questions that your organization should ask whenever someone refuses to come back to the worksite, in order to determine, as an organization, whether that employee might have a legally protected right to work from home. And so the first question is about the disability issue. Does that employee have a disability that prevents him or her from returning to the worksite? For example, if the employee can't get vaccinated because of a medical condition, and then therefore the employee is at risk for returning to the worksite, working from home might, I stress might be a reasonable accommodation for that employee to continue working, not lose their job, continue working remotely, either until the employee can become vaccinated or until the risk of COVID is dramatically lower or even eliminated. Or, for example, even in the non-COVID context, I know a lot of our clients have dealt with this before, COVID-19, if an employee breaks his or her ankle, can't commute into work, remote work might be a temporary accommodation of that medical condition. The second question you should ask is if the employee has a sincerely held religious belief or practice, but an issue we've been talking about throughout the program. Well, if that employee's religious belief prevents vaccination, then permitting that employee to work remotely might be a reasonable accommodation of that employee's religious belief. And that's a question you should ask. The third question, may be the most important question when a worker refuses to come back to the work site, is, well, can that employee's primary job duties, can they be performed remotely? And different positions obviously may be more or less appropriate for remote work. The marketing assistant who can create work product from home, who can attend meetings via phone or Zoom, albeit not a perfect solution, but he or she can likely perform his or her core job duties remotely on a remote basis. So if they have a disability or a religious belief that needs to be accommodated, that type of employee can likely be accommodated via a remote work arrangement, and they might have a right to continue working remotely. But your front desk receptionist, or for some of you listening today, an event coordinator at your organization, someone who needs to be physically on site to troubleshoot issues that arise during an event, he or she likely cannot work remotely. And therefore, even if that type of employee has a disability or a religious belief that needs to be accommodated, you might need to explore that employee other accommodations that don't include remote work. And that's a situation where that type of employee will not have a legal right to insist that they get to continue to work on a remote basis. The fourth question here is about whether your organization has made exceptions to the return to work rule for similarly situated employees. And this really relates to potential discrimination issues. If you have two employees, both who have job duties that are capable of being performed remotely, but one employee is allowed to work remotely and the other's required to come back into the work site or risk losing their job, well, you can begin to see how that kind of fact pattern might lend itself to a potential discrimination claim, especially if the two employees are members of different protected classes. And the last bullet here, I'm going to skip at-will employment because I talked about that at the front of the slide. But the last bullet here is the importance of written remote work agreements. And it's really difficult for me to overstate how important it is to have either a written remote work agreement or at least a written remote work policy. Now, why do I say that? Well, your written agreement or policy can and should include an acknowledgement by the employee that working remotely is a privilege. It's not a guaranteed right that's going to last forever. And so the employer can say this in the policy or the agreement. The employer might revoke that privilege at any time, especially when it's safe to return to the worksite. And related to that issue I just mentioned about whether an employee's primary job duties may be performed, or are capable of being performed remotely, your written remote work agreement or your policy, it can also include another acknowledgement that some of the employee's job duties, and this would be specific to each employee, but some of their job duties aren't capable of being performed remotely. What we were really doing during COVID, there were a lot of jobs that all of the job duties couldn't be performed remotely, but we were just doing the best we could because it wasn't an option to have people return to the worksite. It wasn't safe. Now, as it becomes safe again, it's important to have written acknowledgements with your staff that some of their job duties, their primary job duties, need to be performed in the office. And I can't tell you how important this type of documentation is when a dispute does arise, because your HR department, your manager, whoever, they can have a mature but polite conversation with the employee and said, well, you signed this document, excuse me, at the outset or in the middle of the remote work arrangement. You acknowledge that you might be asked to to return to work, and that some of your job duties need to be performed, physically at the work site. So we're now, compliant. We're adhering to that document, the document you signed and you acknowledge, and we're asking you to come back. So that's our program. We are at the 3 o'clock hour. If you'd indulge me, I'm just going to answer one question that came up for 3 or 4 of you, and then we're going to have to end. But a couple of you asked during the program, may we have different vaccine policies for different classes of employees? And while the technical answer to that is yes, you're strongly recommended, though, that it's tied to a business purpose. And that's because of the obvious discrimination or disparate treatment issues that could crop up. You can't, by different classes of employees, it shouldn't be things about, well, managers don't have to get vaccinated. They can just wear masks if they come back to the office, but non-managers, they all have to get vaccinated. That's going to lend itself, at best, you're just going to have workplace morale issues. And at worst, you're going to have discrimination claims. People suffer a consequence for not complying with that policy. So by different classes of employees, we mean have it tied back to a legitimate business reason. Say, well, people who exclusively perform their work remotely, they don't have to get vaccinated, but people who are going to come back into the workplace on occasion, they have a uniform policy for those types of employees. I'm sorry we couldn't get to all of your questions during today's program. We want to be mindful of everybody's time. I thank you all, and on behalf of my co-presenters, thank you so much for everybody attending. As mentioned, we're going to send you all a copy of this recording, as well as the Q&A document where we answer your questions in writing. And again, that code for CLE is vaccine, and you'll be hearing from us soon to get your CLE credit for all the lawyers on the call. Thank you so much, and have a great day.